All right, I think we are right here at the 11 o'clock mark. We are going to go ahead and start our Launch and Learn. Welcome to the SC Launch and Learn with Dr. Larry Boyd. Today we are discussing intellectual property from an innovator's perspective. Before we begin, I'd like to go over 2 webinar housekeeping items. First of all, if you can hear me, please go ahead and raise your hand in the webinar controls. I'll pause for a minute to see if people can hear me. Thank you, Andrew. Can anybody else hear me? Lauren, Robert, great. Okay, I'm going to go ahead and lower everybody's hand and continue. Now, on the format of today's webinar, we will keep all audience audio muted. So if you have any questions, please feel free to type them into the webinar controls at any time. We will be taking a few breaks during this webinar for Q&A. I will be reading the questions out loud that are typed in, and Dr. Boyd will be answering them. With me is Dr. Larry Boyd. Dr. Boyd is an international leader in medical device innovation with over 60 issued U.S. patents for medical devices and related procedures. Dr. Boyd is an experienced business leader and entrepreneur, having founded 2 medical device-focused ventures. He has more than 2 decades of experience leading product development, engineering, and business development efforts for medical devices in the orthopedic and spine surgery space. Dr. Boyd provides a range of services, including product development, prototyping, IP strategy, business development, venture due diligence, surgeon and staff training, as well as technical writing. For all of you on the webinar, my name is Julia Linton, and I am the Operations Manager for the SC Launch Program. Dr. Boyd, I'd like to welcome you here, and the mic is now yours. Dr. Boyd.
Hey, thank you, Julia. I appreciate the opportunity. Really enjoy working with SCRA, love everything that you do. As you can see from this first slide, I'm coming to you from Durham, North Carolina. Recently had a chance to join a great company here in Bioventus. They were actually a consulting client and made me a great offer to come on board. So I'm happy to be coming to you here from Durham, but love South Carolina, live in South Carolina, have a home there. Actually have helped and continue to help SCRA with a lot of what they're doing around medical devices, as well as being engaged with Clemson in a volunteer role helping the bioengineering program out there. So a lot of what we're talking about here is super relevant. I hope that we have some really good discussion. Thank you, everyone, for joining in. Trouble advancing the slide. Hold on a sec. Let's try that again. Hold on, guys. Here we go. Yep, next slide. Okay. So quick outline. Tell you a little bit about Palmetto and some of the things that I've done in this space, and then we'll just a real high-level review of IP and particularly patent basics, a little bit about infringement. I'll give you a quick example of some work I've done on the licensing front, and then we'll take a break. We'll take your questions, hopefully have some discussion, and then we'll go back into the startup side of things and talk about one of my ventures that had an IP component to it that's probably worth talking about. So hope to have some good discussion here. Again, I think as Julia mentioned, I started Palmetto really as a consulting venture, but then wound up doing a fair amount of inventing. We spun 2 companies out of Palmetto, BioShape here in North Carolina, and then View Medical. I'll talk about the Surgilite a little bit later on as Tennessee Corporation. Been in medical device leadership management for many years. Many of the things that I do are involving IP, have worked closely with IP attorneys, both within and outside of the organizations, and I've been fortunate to be involved in inventing quite a bit. So now 68 issued U.S. patents, hopefully growing. And then academically, I had an opportunity to spend a fair amount of time on campus at Duke, finished my doctorate there, and stayed on. We built a student business incubator. A lot of the concerns that students had often involved IP, so we'd bring in outside attorneys, and I'd provide some advice, and then did some teaching as well around entrepreneurship. And some of the slides you'll see here today come from that work. I think IP is fun. I think it's really exciting. It may not be the first thing that comes to mind, but I think there's a lot of enjoyment there. It's a very challenging area, and it's important for the profitability of your venture as well. So it may not be the first thing you think of, but think about those attorneys at some point. The intellectual property is really embedded in our Constitution. And so you can see here that Congress basically grants authors and inventors a right for a limited time to their inventions and their writings. But remember, that is for a limited time period. Oh, I don't know why it's sort of popping in and out on me here. There may be a little bit of a lag. I apologize, folks. Ah, there we go. Got it. Sorry, guys. And again, that's the big point here. It's for a limited time. We'll talk about that, but you don't have the opportunity to exploit those forever. It's limited to, in the case of a patent, 20 years from the time that you file it. So intellectual property is property. We'll talk about claims in a patent. Think of them as a fence around your property. Those are the bounds that you create. The government can enforce those laws around this property. You can exclude others. That does not mean that you have the right to practice your invention. If you infringe on somebody else's invention at the same time, we can talk about that if you'd like. It's property that you can sell, gift, convey, license. You can have a lien placed on it. And it's a subset of what we call intellectual capital. Intellectual capital really broadly is the experience, know-how, skills, creativity. How do you protect this? Well, for example, you might do that through a non-compete agreement. You don't want your employees who have all this knowledge that they've gained on your dime, if you will, as a company, going and competing against you, at least for a period of time. The intellectual assets, documents, ideas, drawings, those things, you can protect with confidentiality agreements. You keep them secret as a trade secret. And then intellectual property itself, which includes patents, copyrights, trademarks, etc. So that's what I mean by sort of the subset. I'm not going to talk a lot about these other subjects, but trademarks basically are words, designs, and markings that identify or distinguish that particular product name. Copyrights are creative expression in some type of medium, really fascinating, much longer lasting coverage than patents. For some cases, trade secrets might be appropriate. In that case, you don't have to worry about your patent expiring. If you keep it secret, it lasts as long as that secret is kept. Lots of guidelines there in terms of trade secrets. And then I'm going to talk mostly about utility patents, which are inventions, and then design patents, which are really just ornamental features, not functional. So going to patents, Abe here pointed out, which I think this is really relevant, this system really created a lot of incentive for people to really get working on inventing and innovating, because you've got a way to benefit from your invention, selling it, excluding others, etc. Patents, again, if you're in the medical field, patent is, sort of patent blood vessel is an open vessel. And so it's important that you fully disclose everything about your invention. That's actually part of the deal. You have to tell the best methods. You can't hold a little bit back. In fact, you could hurt your potential patent if it comes out later that you didn't disclose the best methods. At expiration, it goes in the public domain. That's sort of the deal that you make. 20 years from filing, you can extend that period if there's a delay in the prosecution for some reason. And I'm going to talk really about utility and design patents. So a design patent, again, is just ornamental or decorative. It protects both 3 or 2-dimensional features. It can't contribute to function in any way, but it can be one part of the overall patent coverage of a, in my case, medical device, some sort of a feature that is very unique that you want to cover. We've seen it, for example, in the curvature on the iPhones, for example. That particular curvature, those sort of things are things that people might try to make a design patent out of. Typically, they're not widely used, at least in the industries that I've worked in. Utility patents, 4 criteria. It's got to be new, so you can't point to any given invention that has previous invention that has everything that you have in your invention. Okay, that's usually pretty easy to do. You're normally careful not to copy something exactly, for example, right? Useful is usually fairly easy to meet as well. You can see sort of the statement here. I think most of the inventions that we would work on here would fall into that useful category. This is the tough one. non-obvious, right? Sufficiently innovative so that a person of ordinary skill, I underline that because there's a lot of debate about who's that ordinary skilled person, that they wouldn't be readily able to deduce it from publicly available information. This is where most of the back and forth, rejection, amendment goes with the patent examiner. And then fully disclose. As I mentioned, you've got to disclose the best manner of doing it. You have to give them drawings in an adequate fashion. A lot of the rejections that we seem to get are around the drawings not being adequate, or us not having adequately verbalized the invention in the way that the patent office requires. So prosecuting a patent. Used to be that the U.S. was a first to invent area as opposed to the rest of the world. We've gone to the first to file system, so it's important that you not publicly disclose your invention prior to filing at least a provisional patent, if not a regular utility application. We can talk about provisional versus full utilities if you'd like at some point. But remember, as I mentioned, the claims are the way that you define your boundaries. If they're product related, they might talk about the structure or composition of your product or method, how to practice it, how to make it, how to manufacture it. Sometimes those are a little harder to enforce because you may not have visibility into the actual manufacturing method, for example. And in the US, again, you get a 1-year grace period. So if there is a public disclosure, you've got a year still to file. That's not true in the rest of the world. So typically be very careful about public disclosures. That can be a very common topic of discussion with innovators. Claims can be very broad, so you can have a really wide fence around your property, or they can be relatively narrow. The advantage to that is if they're more narrow, they're more likely to be enforceable. They're more likely to survive examination. The examiner is likely to give you what you ask for if they're fairly narrow, and they're less likely to be invalidated if you get involved in litigation. So there's a trade-off there. Typically, you ask for the broadest coverage possible, and over time with back and forth with the examiner, you wind up refining and narrowing your subject matter somewhat. So this is what the structure looks like. This is one of my inventions for a device for injecting a biomaterial into the intervertebral disc. There's really 3 main components to the independent claim. You can see them there. So for somebody to infringe on this, they would have to embody all 3 of those individual aspects. And then the dependent claims are here to just add additional breadth. If somebody infringes, we're going to look at not just the independent claim, but the number of dependent claims that they also infringe. I typically look at independent claims first to sort of understand how many of them there are, what they cover, and then start to spend a little bit of time looking at the dependent claims. Liability. So infringement, again, this is this idea of trespassing onto your property that you've laid out with your claims. Somebody makes, uses, offers to sell, or imports a patented product or process without the owner's permission. There can be literal infringement or substantially similar. So they don't have to directly, literally infringe, and very often you're looking at what's called the doctrine of equivalence, where, okay, it's not literal, but this product or process performs the same function in substantially the same way and achieves substantially the same result. Now, this is really heavy legal territory. I'm not an attorney. This is just to get you aware of some of these concepts, but you can wind up infringing on something even if you may not directly point by point infringe if you sort of fall under this doctrine of equivalence. How do you defend against infringement? Well, you may go back and say, you know what, if you interpret these claims correctly, we don't infringe. We don't fall into that territory. You may say, you know what, those claims aren't valid. The examiner missed some very relevant references that would have been prior art, and so should not have been issued. We're gonna challenge that. Maybe it's unenforceable because of the conduct in the process. They left out inventors. They didn't disclose everything. And then finally, I've never seen this, but it could happen. Maybe it would violate antitrust laws. So those are some of the ways you might defend against infringement. You can imagine this is a very, very laborious and expensive process, right? It can cost tens of thousands, millions of dollars even, to get into an infringement case between 2 companies. So typically you try to avoid that, work through the system without actually getting to court. Okay, just a bit on licensing. I found this really interesting. Patent licensing actually at one time was the way that most innovation was done. You had these individual inventors out there, and they were licensing their ideas, their inventions, to the bigger companies. Of course, that's changed. Many companies have very sizable internal development efforts. There aren't so many of the big individual inventors out there. There's some. I do want to point out that there's a difference between an inventor that actually plans on putting their invention into commerce and somebody who files or buys a patent solely with the purpose of essentially getting, extorting, if you will, in some ways almost, fees from others to practice, right? They don't plan on practicing it. They're going after others, and these are non-practicing entities, sometimes called patent trolls. And a lot of the recent patent law is addressing this aspect of our current system and making it more difficult for these patent trolls, if you will, to prosecute others. Quick case study, and then we'll take a break for some of your questions. I worked for about 10 years in Memphis for Medtronic, a division of Medtronic, and then I went to Duke to do a doctorate. While I was there, I had the good fortune to take a really fascinating class by Dr. Nicholson on tissue engineering, who worked on a particular tissue that I knew well, the nucleus, the center portion of the disc. And in the process of working on that project, I came up with some ideas, in one case with another student, for delivering that particular substance, whether it was a gel or a gel with cells or whatever, into the disc. And I thought, well, there could be something here. I don't know that anybody's ever really thought as much or disclosed some of these ways of delivering this gel to the disc. These are some of my hand sketches. There's more, but this is just sort of a narrative. I never prototyped it. It was really just a hand sketch with narrative sort of invention. Of course, those inventions eventually became detailed drawings working with my patent attorney. A provisional patent was filed. Again, we can talk about that more if you'd like. And then eventually a regular application was filed. And this publication was made 18 months from filing. It's not an issued patent. It's just a publication. It's a way for the others in the community to see what others are up to and not be surprised by some sort of inventive effort. There's a discussion of this term sort of submarine patent, where in the old days, some of these inventors would try to delay issuance of their patents, and then up they would pop after others were already practicing in that field, unaware that there were already patents in the works. The figures, again, this is working closely with the attorney. We did not prototype this, so these are sort of my own sketches that became patent drawings, working with a draftsman, and then working together with the attorney to sort of put together a description of how this functions, as well as putting together some of the proposed claims. So what we do, this was our invention. We did it as part of class. There were no funds provided for prototyping, no real faculty involvement. So we were clear that we owned this. I had paid essentially for the provisional patent to be filed. So we went out and presented back to my old company, Medtronic, and at some point I think we just got into discussions, decided that wasn't going to work, said, you know what, I'm going to move on. Approached another startup, SpineWave. They had just raised or were about to raise Series A funding. This is actually a technology that fit perfectly with what they were doing, and these were some individuals that I knew from my previous work. And so we presented to them, got to a term sheet for them actually acquiring the intellectual property, and ultimately multiple agreements were put in place with SpineWave around a little bit of equity and some purchase price. So ultimately, this is an asset for SpineWave. These are now a number of patents that have issued around this delivery technology. It works well with their existing disc repair technology. And so one of the things that you want to think about when you're thinking about a license, and in my case, again, I sold the patent outright to them because that was their wish. But if you are going to license, exclusivity. Do they have exclusive rights in all fields? What if somebody modifies it? What if you modify it and continue to invent? Do they own the improvements? How long does it last? You can get royalties. How do those work? Are those on net sales, gross sales, cross-licensing possibilities? Can they cross-license it? Do you want a bit of an upfront payment plus royalty? And then who can sub-license it? These are all things you have to sort of think about if you get involved in that sort of licensing side of things. I will say, coming out of this experience, I tried to figure out the way to sort of increase the value as much as possible without spending a lot of money, right? So again, document it very well, figure out if there's an ownership involvement. I did have to have a legal agreement structured with the other co-inventor in terms of percent ownership. I wanted to make sure we got that in place first. I did file a provisional application. I like provisional applications. I write most of them myself and then hand them over to the attorney to finalize them. They typically add a lot of value for a few hours of work, and then they file it. If you write your provisional well, it's a great start on your ultimate utility, and you have a year to sort of decide. And there's a number of inventions that I've filed provisionals on and then abandoned as I spent the year trying to figure out if there was an opportunity, if anybody was interested, have the market conditions changed. So that, in my case, that's a way to kind of buy some time relatively inexpensively. If you can build a prototype, I usually do. In this case, I didn't really need to. I felt like I could sketch it out pretty well, but I normally do prototype these. Given the advanced capabilities available today, that's not too hard to do and pretty reasonable. I talk with companies. I typically put a NDA in place, even though I have a provisional filed. You just never know what additional things you may disclose. Try to get to a term sheet. And then ultimately, there can be a mix of incentives to you and them. A little bit of upfront money, stock options, consulting agreements, royalties. These are all things that you might consider as you talk with a potential interested party. So that's a little bit about kind of the licensing side of things, a little bit of background on what is a fairly massive area in terms of intellectual property. But I want to take a break here and pause to see what sort of questions or observations the audience might have.
Great. Thank you, Dr. Boyd. We'll let you take a minute and take a sip of water and just relax for a second. And we will wait to see the questions come in. Just as a reminder, you can go ahead and type your questions into the webinar controls. Looks like we've got something that just came in. All right, so starting at the top, Dr. Boyd, how did you identify potential licensees? Dr. Boyd?
Good question. Yeah, good question. So, in my case, I tend to invent within fields I know pretty well or adjacent fields. So in my case, this was a spinal concept that I'd been involved in that marketplace. I knew the companies well. If I have a physician who's a co-inventor, they know companies. And so that's relatively straightforward. If you're outside of an area that you know well, it's harder to make those relationships. You're doing things on LinkedIn, you're going up to booths at meetings that are technical meetings. In my case, the American Academy of Orthopedic Surgeons. A lot of people do shop their ideas to companies at those types of meetings. But if you stay in an area that you know well or that your co-inventors know well, you've got a head start.
Great, thank you. So the next question is about the time that you were working at Duke as a student. And the question is, Duke did not want you to assign the IP to them. How did you get around that?
Yeah, so it was a class. It was not a design class. The class actually was focused on designing the biomaterial, and so the delivery aspect wasn't part of it. There's no faculty involvement. I will say there's still a pretty fair amount of conversation with tech transfer or OLV in Duke's case. I had already filed a provisional patent at that point, so it was pretty clear the amount of effort that I'd put into it versus the little bit that came out of the class. So I think it's a good question. I think that's not always going to be the case, especially when you have faculty involvement. But in my case, the two of us were really working on a very different sort of class, and I was adding quite a bit of value based on my history.
Good question. I'd like to encourage you all to keep typing in your questions. We've got another one here that just came in. It is, did Medtronic come after you because you had worked for them first, then had this idea?
Great question again. I'd been gone for more than a year. So before I ever worked on that project, I had been unemployed by them, or not employed by them, I guess is the right word, for more than a year. So the agreement basically specified that, if I invented something within a year, they would sort of presuppose it was theirs. We'd have to prove otherwise. After a year, that presupposition didn't exist. Were there still conversations around that? Yes. But I think if you look at the particulars of it, There was nothing in there that was particularly related to projects that I've been working on at the time directly. Good question.
Yeah, lots of great questions. Unless we have another one that comes in just a minute, we will go ahead and get started again, and then we will open back up for questions at the end. So, Dr. Boyd, I'm going to hand it back over to you. The floor is yours. The mic is
Great,
yours.
thank you. Hey, good questions, everybody. Think of some more if there are. This is just sort of a little final portion to talk through one portion that's IP related, but really the broader case of one of the ventures that I created. This is the second company I worked on. I think I probably learned some lessons from the first one that didn't pan out quite as well. And it involves this idea of surgical lighting. So you can see some of the overhead lights that are used in surgery, or these headlights that may have cables, may not. So, felt like there was an opportunity there, made aware of it through some conversations with physicians and others that this was an area of challenge. And I was in the OR quite a bit as well for various reasons. So if you look at the overhead lights, they're really not made for a very small opening like we're doing with minimally invasive surgeries. They're really diffuse, so they're great for a wide field. But when you start to get into a cavity, you're operating inside an opening through the skin, not ideal. Headlamps are what that's really for. They can provide a very directed light. There's some issues there. There are some now that have rechargeable battery packs, but many of them still have wired leads, light sources. And so, there's some issues with that sterility-wise, and also just wearing that on your head for a 3 or 4 hour case that adds some weight and can be neck strain related. And they're constantly moving around as the surgeon moves their head, as you can imagine, right? And then you can light the actual retractor blades down into the wound. They have some challenges with heat generation. They take up some space. There's just, they're not perfect either. So surgeons always need more light. You can never have enough light. You need to be able to see what you're doing. So this was one of those few kind of aha moments where I recognized the fact that there was an access point, an anchor point in the OR. So if you can see on the left here, these little coverings, this green plastic covering screws into the overhead light. It's sterile, and the surgeon actually screws that in. That's kind of part of their process of going through getting set up for surgery, and that allows them to actually adjust the light and target it and shine it where they want to shine it. And so I realized pretty quickly that was a potential anchor point for essentially a snake light, independently powered, controllable, high-powered LED. So you can see there in the middle, this is what I'll call our MVP, a minimally viable product. I mean, this is basically me buying a box of these green handles, going to Radio Shack and buying some switches, getting on Sears' website and ordering all the different LED task lights that they have, and putting together something that I could show somebody and say, hey, what do you think about this? Not ideal, but good enough. And turned out that the surgeon said, yeah, you know what, I think that's something that we could use. We actually took that idea, I'd filed a provisional by that point, into an incubator in Memphis called 0 to 510. And lo and behold, received some funding for the summer with a little bit of equity back to the incubator and some of their key advisors. So over the summer, $75,000. Co-invented this with an undergrad that was working for me out of NC State. I was actually based at the First Flight Venture Center here in North Carolina, so did all this work off campus, and got to send him over to Memphis for the summer to work on this as part of that program, the 0 to 510 program, along with 2 other undergrads. Actually, one undergrad from University of Memphis and one MBA student who was the CEO for the summer. They did a great job over the summer putting together the business plans, putting together the next generation prototypes with the funding. And we actually did a fair amount of that work with a local firm here called Galero that does that sort of prototyping work. And we received another $100,000 in follow-on funding. So we were sort of off and running over the summer. This is sort of the initial case of the prototype coming into the summer. A little bit nicer looking than the duct tape and the green electrical tape version that you saw earlier. Pretty functional. We had a nice narrative that we could show to the 0 to 510 folks. And then coming out of the summer, essentially going into fall and into the spring with the help of Galero, really put together a very functional next generation conception. as well as this idea of having a sterility barrier, as you can see in sort of the top right corner, and a disposable battery pack. So this is a unit that is, rechargeable battery pack. This is a unit that you can replace the batteries fairly easily, even in the middle of surgery if you need to. And so that was kind of our next generation conception, much more of a commercial product, a handle at the end that's sterile that you put on and then wrap that sleeve back. And so that was really important to us. IP, of course, was important as well. I had filed a provisional patent. In that provisional patent, we had the sleeve idea for sterility. Also, this is an interesting point, I think, perhaps. If you look in the bottom right there, this concept of a camera attachment. So not a light, but having a camera that you could use to film a procedure and record the procedure, either in combination with the light or not. We added that in, even though that wasn't part of our initial prototyping. We have some claims around that as well. So initial claims were fairly broad, right? A first housing with this light handle attachment back to the overhead light, a second housing that's connected to a power source and a shaft in between them, and you can uncouple and decouple it, and it's a self-contained unit. It's got a power source, it's got a control capability, it's got the ability to keep it sterile through the sleeve, and so that was kind of the basis of our intellectual property for this Surgilite. Overall, the process, again, filed a provisional patent even before entering into the incubator, converted that to a regular utility application after the company was formed. That equity was really sort of my basis, or that invention was really my basis for equity in the company, if you will. The application published 18 months after filing, so what you see there is the published application. And then a lot of work back and forth with the examiner, and still in process, amending the claims, discussing with them, going in and having an interview with the examiner to talk through the novelty of it, because as you can imagine, the basis of their rejections were often, well, this is pretty obvious to somebody skilled in the art, to combine these things, So what's really novel about this, and having to really explain to them what's different about it versus the prior art, the releasable coupling, the independent power source, independent control elements, adjustable light source, and back and forth. At some point, we changed attorneys. We felt like we needed just a different set of eyes. We've now amended those claims. We're in the process of potentially getting to a point where some claims will issue, and then perhaps if we need to, we'll appeal for broader claims. I did mention we did file a design patent just to get some coverage. We felt like some of the look and feel of it was novel, and so that design patent has now issued. And we've got international applications in process lagging behind the U.S. activity. So this is some of the prior art that we're struggling against, right? I mean, these are not independently powered, independently controlled lights, but they're lights. And so we're really having to sort of make a case for it's really not obvious to come up with the ways that we come up with adapting to all the various types of overhead lights, independently powering it, independently controlling it. You can see there in the bottom right this GoPro attachment, so you can actually have lighting and recording at the same time. But the patent office is now, I think, more biased towards rejecting than allowing. That's a good thing in some ways. You don't want to have unnecessary broad patents that shouldn't have issued that you have to sort of work against in the marketplace. So I think there's always a balance there. We're still in process of working through that with the examiner and with our attorneys to hopefully get something to issue. And again, as I mentioned, this is really the main thing that you run up against, this issue of non-obviousness. It's really the majority of the reason why things are rejected. And this all comes back to this person that's skilled in the state of the art. And there's many, many different ways you can come at overcoming non-obviousness. In fact, even commercial success is one way that you can argue, well, if it was so obvious, here we have this very successful product, why didn't somebody do it first? There's a variety of angles you can come at it. That's really a case of working with your attorney to work through those. So that's kind of the IP side of it. I want to finish the story though. So We basically had received $100,000 funding from these two venture firms, needed additional funding to commercialize the product. We're running very, very low on funds. Our students had gone back to school, so myself and another individual that runs an incubator in Memphis were carrying it forward. One of the venture firms said, yep, we're in for half, here's a term sheet. And the other firm basically said, no, we're not sure that we're interested. And so we're in a position of trying to raise some matching funds for that existing term sheet and really got stuck for essentially a year. Luckily, our burn rate was very low, really primarily around intellectual property. And so for a long time there, this was sort of in limbo a little bit. And then lo and behold, through one of my partners, we came across a company that made handheld disposable lights for surgery. That's what they did. This is a good fit for their business. We went in and presented to them, hoping they would perhaps even buy the company. They said they're not interested in purchasing the company, but they're a manufacturer. They'd love to make the product for us. If we'll give them exclusive manufacturing rights for a period of time, they'll share the distribution rights and any net profits with us. That seemed like a really good deal. And they're a very skilled German-based medical device company. This is a small component of their business that does surgical lighting, but they know what they're doing. They jumped on it eventually after we came to an agreement and really started to deconstruct the design, looking at the power source, looking at the light source, finding the best LED, the most efficient LED, designing the sleeves and figuring out how we're going to validate some of those. And so eventually, within about a year and a half, we had these prototypes that we were able to take into cadaver labs, into veterinary surgery, certainly not ready for human surgery, and get some good evaluation of this Surgilite concept. So that was by early 2017. And then, the manufacturing process just takes a long time. Design controls take a long time. Anybody who's gone through stage gate knows how long that takes, and they're working on other projects too. So it really hasn't been until, we've shown the product at meetings, but it really hasn't been until early this year that we've been able to launch this product through BeelerMed. This is actually a group of us at the American Academy of Orthopedic Surgeons. It was featured at the BeelerMed booth. The gentleman to my left, that's me in the middle with the red tie, is Gary Stevenson. He runs MB Ventures. They're the primary funding right now for this particular venture. Dan Coppersmith in the middle is the head of marketing for BeelerMed, and then Mike Sherman is actually the interim CEO for View Medical right now, came out of MB Ventures. So you can see the current design. We've got an operator's manual. We're training people, getting ready to introduce it into the operating room, hopefully even this month. We've got units on the shelf. We've got thousands of these handles with the disposable sleeve to go around it. And we're really looking forward to getting actual clinical feedback, though we've been showing it to orthopedic surgeons, thoracic surgeons, gynecological surgeons for quite some while. And then finally coming out of the academy, this was kind of cool. There's a magazine that basically is outpatient surgery focused, and they identified their 20 hot new products for 2019 coming out of the academy, and we were one of the products that they featured as an innovative new product coming out of academy. So that was nice to get that attention. You can see it's been a long road, right? 2013 to 2019, we've had some ups and downs. The IP continues to be an area that we're going to have to continue to work to get some good coverage, but we feel like having a really viable commercial product here is going to also maybe help make some of those cases with the patent office. I'll recommend this heavily to you as a great resource. This is put out by, funded by Gary Michelson, who's a super prolific individual inventor that I worked with over years when I was at Sophomore Organic and Medtronic. It's a free download. It's a great book. You can download the PDF. You can order a softcover copy if you'd like. If you're teaching classes, it may be great for your students to look at it. It not only goes through the IP basics, but really some of the things that we talked about in terms of how to exploit and protect your invention. So that's all I've got. I wanted to run through that as an example. Maybe that stimulated some additional thought for those of you that are involved in startups or trying to take technology out of universities and get companies started. and I'll look forward to your questions in the discussion.
All right, great. Thank you so much, Larry. Thank you, thank you. We will open this back up for questions, and then we will, I'll post them again to Larry, and he will answer them. So get those questions in, and we'll just take a minute for that. All right, so we have no questions coming in. Oh, there we go. There we go. Mitchell, thank you. Oh, here they come. Here they come. All right, the first question on the table is, as an inventor, what do you think is necessary for an ecosystem that encourages innovation?
I think it's really about a couple things. I think one is getting exposed to problems that need solutions, right? And so I think that, you know, what a lot of the universities are doing, at least in the biomedical engineering space, is getting students out into the clinic to understand the problems and maybe even spot problems that the clinicians don't know how to articulate themselves. I think the other side of it is just a robust network of people with different viewpoints, different experiences. Just, you know, I don't invent in a vacuum usually, right? I mean, I'm typically talking with clinicians, interacting with people that have the problems, working with an engineer that's doing the CAD work for me mostly. You know, it is a team sport. So I think those are parts of it, is having that support. And then at some point, obviously, you can see, you know, the View Medical thing wouldn't have happened without some financial support in the state of Tennessee with that incubator that helped to give my students that were working on this for the summer, you know, help them get exposed to the process. So the innovation was done to some degree, still a lot of work to be done, but the initial idea, but it still had a long way to go before it was ready for the market. And that's where this 0 to 510 incubator or processes like that with seasoned people advising them really helped.
Great, thank you. The next question on the table is, what do you value most in a licensing transaction? And this is in terms of compensation. What do you value most?
Me personally, you know, it's interesting. With the View Medical Light, I wanted to double dip, if you will. I wanted equity in the venture and a royalty. That wasn't going to work for them. The royalty was something that the company that was being founded didn't want to have, you know, be stuck with as a trailing expense. And so it was purely equity-based plus a little bit of payment back for my investment. So I do like royalties. Obviously, there's a huge upside to you as an inventor. Of course, it can be zero if the product's not commercialized. And so I think some sort of a mix of equity and royalty could work. But I like the equity side because if the company's successful, even if your particular piece of it for some reason isn't, maybe you're able to help move the needle with that company. So I think equity is a good piece of it for me. I think being involved as a consultant helps. I'm part of the company. I can help move it along. I'm not that with View Medical. I didn't want them to pay me consulting and keep their money for other things. But those are some of the things that I keep in mind. I think equity is definitely an important component. And you know, being reasonable about what's a fair percentage based on my contribution.
Great, thank you. Another question has come in. It says, have you had issues negotiating with co-inventors, and how did you navigate those issues?
That's always tough. You know, I mean, I think that my initial invention I talked about that I did at Duke, where I had another student, you know, I still wound up giving them a fairly decent proportion of it, certainly not half. In other cases, I've worked with a resident who we did some inventing together and wound up giving them a very fair proportion, given the amount of effort that I put into it, but it was really sort of their genesis of the idea. And so, yeah, I think dealing with co-inventors, just like in a startup, dealing with equity distribution, it's always contentious a little bit because, you know, everybody thinks the other person maybe isn't putting as much in. So, yeah, that is tough. It is tough, and I think you just have to try to come to some reasonable understanding.
Great. All right, looks like there are no more questions on the table. I'd like to just stop now and thank you, Dr. Boyd, for your time and presenting us with all of this knowledge. And to all the attendees, we will be sending out I'll be sending out an email shortly with an updated slide deck and contact information directly to Dr. Boyd if you have any other questions. So, Dr. Boyd, thank you so much. And everybody on the line, thank you for attending. Bye.
Thank you very much. I appreciate it.